In what was the shortest week of public hearings at the Madlanga Commission, we saw Northwest businessman, that is Brian Mokgotsi, deliver a sick note that was deemed to be useless. Suspended SAP's component head for organised crime, that is Major General Richard Shabiri, admits that there has to some extent been an infiltration of alleged cartels in the criminal justice system. But before this evidence could be digested and tested, it was halted by Northwest businessman Suleiman Karim's return to the probe with yet another application, this time to give his evidence behind closed doors. I'm Kani Mapanga, and this is the Madlanga Wrap.
It is my considered professional view that in some instances, criminal syndicates have infiltrated or exerted influence within the law enforcement structure. The phenomenon is not recent, isolated or incidental. It has manifested repeatedly over a sustained period of years across different operational environments.
We are not going to sit here and continue receiving useless medical certificates like the last one was and like yours appears to be.
I really have to apologize and reiterate, commissioners, I have been very consistent throughout the preparations all the time before the commission. Coming back from Cape Town, since Friday I was not okay.
The commission was set to kick off its hearings with the testimony of Northwest businessman Brian Mokgotsi. However, he was a no-show, citing that he was ill. Mokgotsi was ordered to hand in a sick note by the close of business or risk being held in contempt. This latest trend, which impacts the schedule of the commission, raised concerns from the commission's bench.
Let me right away say that it looks like we've reached a stage where we are getting quite a few of these medical certificates, and this is quite bothersome. It impacts negatively on the commission's scheduling, because once we do not have a witness, and we usually get to know of that on the day, we lose time because we do not sit on that day, and it gets worse if a witness has been scheduled for more than just one day. And that witness then has to be scheduled at a later date, affecting scheduling that had already been done. This is truly, truly bothersome, and the commission has very limited time to do its investigation, do and finalize its investigation. And the medical certificates we get basically say nothing. Yours, Mr. Mokgotsi, says medical condition. That is what the last one before yours also said, and we had to insist on getting another medical certificate, which then stated what the real condition was. Just saying medical condition, that's useless, useless. It doesn't assist us, and ordinarily, that's something we just cannot and should not accept. We are aware that there are regulations that govern the medical environment, and we believe that we are entitled to call upon the medical doctor concerned to actually explain what the medical condition is, but because of the confidentiality that attaches to people's medical conditions, that's something we should do in a private session. Starting from now, that is something we are seriously considering doing. In addition to that, we are also entitled to furnish the medical certificate to the council that governs the medical profession, for it to inform us professionally whether what's written on the certificate makes sense medically.
And while Brian Mokgotsi escaped the risk of being held in contempt, his medical note, which was described as useless, still demands answers.
We are not going to sit here and continue receiving useless medical certificates like the last one was and like yours appears to be. Having said that, let me hear you, Mr. Mokgotsi. And unfortunately, anyway, whatever we make of this medical certificate, we cannot hear your testimony today, and that is because we have another witness scheduled for today. Do you want to say anything? Do you want to comment on your own medical certificate, which I say is useless because all it says is medical condition? What on earth is that?
Thank you, Commissioners. I really have to apologize and reiterate, Commissioners, I have been very consistent throughout the preparations all the time before the Commission. And coming back from Cape Town, since Friday, I was not okay. Like you say, confidentiality of the illness, but mine, I just had a lot of pressure, more like a diarrhea. I was so sick. I'm still not well, but I thought because if for the Commission's information, throughout the engagement, it is me who suggested that day to the evidence leader. So I really apologize, but indeed I was very ill and very dizzy also.
The Commission is now at a stage where it is seriously considering calling medical practitioners to testify on the sick notes that they issue, as well as furnishing those said sick notes to the Council to test whether they meet the standards of the medical profession. To unpack this, we are now joined by a representative of the body that governs the health profession, protects the public and guides practitioners, that is Mbuyiseli, the HOD of professional practice at the Health Professions Council of South Africa. Thank you for joining us, Mbuyiseli, and welcome to Connecting the Dots.
Thank you very much, and good afternoon to you and to everyone.
I think where we can start is that in general, if we look at the standards, what is set according to the regulations for the issuing of a sick note by a medical practitioner?
Thank you. Thank you very much for that. Maybe let me start by saying the issue of medical certificates in South Africa is governed by the ethical and professional rules of conduct for all registered practitioners with the Health Professions Council of South Africa. These rules, in the main, they direct practitioners of how to conduct themselves, as well as how to practice their profession in general. And these rules list the minimum requirements that practitioners should adhere to, especially when it comes to these issues of issuance of medical certificates. So the rules are there. Practitioners must ensure that they adhere to the minimum in order to ensure that whatever certificate that they are producing is valid and legitimate. Thanks.
Indeed, speaking of that minimum, in terms of a sick note issued for the purposes of providing it to a work environment, or in this case, to a commission of inquiry, what are the explicit details that are needed to deem the sick note satisfactory legally?
Thank you. This certificate, in order for it to be valid, in line with these ethical rules that I've just explained, firstly, they must have the practitioner's details, the details of the issuer, as well as the valid signature of such a person. There must be also the patient details, the one who is interacting with the practitioners in this consultation process. There must also be the details of the consultation, which means the time and date of when did this happen, and most importantly, the date and time of the examination. Remember, issuance of medical certificates is not just a signing of a paper and handing it over. That is the product of a consultation that was occurred between the practitioner as well as the patient. So the examination date must also be indicated on that certificate. And also, there must be a basis for such medical certificates to be issued, whether it is being issued as a result of examination by the practitioner or there is information that has been received from the patient themselves that, in line with the practitioner's professional discretion, it is acceptable in line with their medical training. So the practitioner must indicate such on this certificate, and also the illness. This illness that a patient has arrived with at the consultation room, there must be an indication of such. But in order to be specific with such a expression, there must be a consent provided by the patient. If the patient declines to provide a consent for their illness to be stated as with specificity, it means that then the practitioner can indicate that such and such a person is unfit to work or to conduct their duty of the day, but also there must be an indication whether they will be fit, firstly to fully participate, or there can be some participation with some limited engagement from the patient. So the certificate must indicate such, and most importantly, they must also indicate the dates in which this person who's a patient is expected to be out of duty as a result of the illness that the practitioner has noted on this medical certificate. So these are important items that at minimum must be contained on all medical certificates that are issued in order for that to be valid and authentic. Thank you.
And Paul, this particular sick note listed the description as quote-unquote medical condition. So can a medical practitioner be compelled to divulge further what that medical condition is of a patient to a work environment, or in this case, a commission of inquiry? And if the answer is yes, then what does that mean for patient-doctor confidentiality?
Thank you. Thank you very much. Remember, confidentiality is critical in medical practice. In fact, it's the basis for the relationship between a patient and a practitioner. And when the patient hands over their sensitive health information to a practitioner, there is an expectation that that confidentiality chain will be maintained throughout. However, confidentiality on its own is not absolute. There are limitations that will make a practitioner to divulge health information of a patient, even though the patient may not be necessarily in full agreement. Here are the exceptions or limitations. For example, if there is an instruction of the court or the court order, the practitioner cannot decline or refuse to hand over such information if such exists, or if there are any statutory regulations that compels the practitioners to hand over such information. Sometimes it's not even the lawful instructions, but you may find that the patient themselves has agreed that my information can be handed over, whether to an employer or judicial entity that the patient is agreeing to hand over such information for the furtherance of whatever processes that they are embarking. And the last limitation of this confidentiality processes relates to the issues of public interest. This is where now, in terms of the condition itself and the practitioner's judgment, they can relay the information, of course, to the appropriate entity to ensure that the interest of anyone more than the patient are also taken into account. Otherwise, withholding such information will also be detrimental to the third party or the next person as it is. So there are limitations to this confidentiality, and as I indicated, it's not an absolute arrangement that it must be at all material times be maintained. And if there is a need, for example, for an employer or a judicial structure to request the service provider, who's a practitioner in this instance, to convey specific information if such were not provided for in this issued medical certificate. Certainly, there can be such kind of a request. Thank you.
All right, thank you very much. That was Paul Mbodi of the Health Professions Council of South Africa. We have run out of time, but he was highlighting what the particulars are for a sick note to be deemed legal in the eyes of the Health Professions Council of South Africa. Now, what followed after the sick notes debacle is the evidence of suspended SAPS component head for organized crime, Major General Richard Shibiri, who was the first implicated person to come before the commission and admit that an infiltration of the criminal justice system is a reality. All of those details after the break. And welcome back to Connecting the Dots. Now, on the first before the probe, a Phase 2 implicated person has given evidence which does not seek to pretend that there is no merit at all to the allegations of an infiltration in the criminal justice system.
Based on my experience in the execution of my official duties, intelligence received from registered sources, crime intelligence reports, information derived from investigated case docket, community intelligence structure, it is my considered professional view that in some instances, criminal syndicates have infiltrated or exerted influence within the law enforcement structure.
While Shibiri admits to an alleged infiltration to a certain extent, he also creates limitations in his evidence by stating that it is not institutional, but rather applies to individuals. And he adds that this is nothing new.
The phenomenon has manifested in offense, including but not limited to the following offenses: drug trafficking, taxi-related violence, gang-related violence, kidnapping for ransom, extortion, including the tender-related extortion, fraud and corruption. In some instances...
Sorry, General, can I just ask, would you include illegal mining there?
Yeah, illegal mining also should be here, because I even have an example of illegal mining to show that this happens. So maybe it's an omission.
No, it's not an omission. I see you say, but not limited to. I just want to know if we could include it.
Yeah,
So,
we could include it.
Okay, 51.
In some instances, members of law enforcement have acted in concert with criminal groupings by leaking information, manipulating investigation, and abusing the authority.
While Shibiri acknowledges infiltration, in the same breath he offers denials in response to the allegations against him, which speak to the very infiltration he highlighted in his evidence earlier. For example, Shibiri admits that he received money from alleged cartel member Vusimuzi Cat Matlala. He does not, however, attribute it to the scenario that he painted before the probe, that alleged cartels target vulnerable individuals, but rather says it was a loan.
I confirm that the funds were utilized solely for the vehicle repairs and were not connected to any way to my official duties or any operational matter. The loan has since been repaid in full through my own earnings and proceeds derived from my livestock and personal saving. Mr. Matlala deposited the agreed amount into my son's bank account, forwarded a proof of deposit to me via WhatsApp. My son confirmed the receipt telephonically. My son's bank statement reflected deposit is there to a charge as Annexa RS5. The Annexa will depict proof of deposit, payment of the mechanic, purchase of the vehicle parts, and quotation from the mechanic, attached as Annexa RS6 and Annexa RS6A. I wish to state that I have never attended any function hosted by Matlala, nor he attended any function at my residence. I do not know his residential address.
Shibiri further denied offering an alleged bribe to investigators probing the Armand Swart murder, which implicates alleged cartel member Katiso Katie Molefe.
The allegation that I interfered with influencing or persuaded any investigating officer not to oppose bail is not true. It is inconsistent with my role, my professional experience, the established legal framework governing bail, proceedings, and serious criminal matters. I wish to emphasize that offenses falling under Schedule 6 of Criminal Procedure Act require a formal bail application before a competent court, where the accused bears the honors to satisfying the court that exceptional circumstances exist to justify release on bail. An experienced detective and senior commander with crime detection, I have always been fully conscious of the legal position and the strict procedure and safeguard applicable to such proceedings. Decision relating to bail is opposed or manner which the bail proceedings are conducted or any subsequent appeal process fall within the prosecutorial domain of National Prosecuting Authority. These decisions do not reside within the authority of the National Commander or Senior Detective Officer. It would have been both improper, beyond my mandate to attempt to influence such process. I therefore categorically deny that I persuaded, instructed, influenced any investigating officer not to oppose bail, whether at the first instance during any appeal proceedings. The suggestion that I interfered with the bail process is further contradicted by the testimony of witness A and B before the Commission, whose evidence does not support the allegation attributed to me.
Shibiri also denied allegations that he used a hotel in Northcliffe for shadowy dealings, testifying that his attendance was purely social.
The Villa Spa Hotel and its private lounge were not utilized by me as a venue to influence subordinates, cultivate information, conduct unofficial operations. My attendance was recreational and personal. We were members of SAPs or acquaintances who happened to be in law enforcement accompanied me. They did so on their personal capacity, not pursuant to instruction, operation directive, or expectation of professional engagement. I did not summon junior officers to the venue, nor did I create any environment where investigative matters were to be discussed formally outside official channels.
Shibiri's evidence essentially acknowledges an existence of infiltration in the criminal justice system, but also seeks to suggest that he is void of this particular problem. This evidence will demand further answers from Shibiri in light of the fact that he received money from an alleged cartel member who shows a pattern of allegedly targeting high-ranking SAPS officials for the purposes of guarding his SAPS contract. And that WhatsApp exchanges show that Shibiri took a keen interest in witness A and B's investigations to the extent that they perceived it as his attempt to allegedly influence them into dropping the probe. However, before this evidence could be put to the test on Friday, Suleiman Karim's lawyers arrived with an application to have Karim give his evidence behind closed doors. Lawyers on behalf of Suleiman Karim, a Northwest businessman, accused of using his political influence to assist CAT with his SAPS contract and leaking confidential SAPS information, argued that Karim should be granted an in-camera hearing citing death threats.
The simple proposition is this: it's not the evidence itself, and Commissioner Baloy actually identified that there's a distinguishing feature about this application and how it was brought and when it was brought in respect of other applications. And I adopt that analysis because that's the very point that I want to start with. It's that it's not the actual evidence that my client gives which brings us here, but rather the fact that merely by appearing here on the 6th of February as a confirmed witness who was then granted a postponement and which gave rise to the 4 or 5 threats that we've attached to the 2 affidavits, which don't only threaten my client individually, but also threaten his family.
Evidence leader, Advocate Adila Hassim, in response argued that the in-camera hearing sought by Karim will not eliminate the death threats that he cites as a reason to do so.
The reality is that the relief that Mr. Karim seeks is not going to assist him. The reality is that Mr. Karim is known to the public. His application in the High Court to delay his appearance before this commission was widely broadcast. He then appeared before this commission in order to secure a postponement by agreement. Those proceedings were widely broadcast.
This is not the first time that Karim has brought a challenge to the highly publicized probe. Karim was the first implicated person to take the Madlanga Commission to court in a bid to block his appearance before the probe and review his status as an implicated person. That failed. When Karim had to honor his subpoena before the probe, his lawyers moved for a postponement, which was granted. Then the Friday before his testimony on Monday, his lawyers applied for an in-camera hearing. The commission did not deliver its ruling on Friday afternoon, but instead indicated that it will be delivered at 9:30 a.m. on Monday, when Karim is actually scheduled to give his evidence. This could be seen as a tactical move from the probe, which is faced with a witness who has shown through past acts that he would likely challenge an adverse ruling. Now all eyes are on the commission to see whether Karim will take the stand before the public lens, or will he be allowed to testify behind closed doors? He'll also be followed by Shabiri, who will see his version placed under cross-examination on Wednesday. Join us next week Sunday at 5 p.m. to unpack what emerges from this week's highly anticipated hearings.